can you hear me?
Yeah, hi, Billy.
Hi.
We're going to mute you, so everybody's going to be muted.
Yep. We're just going to start letting people in, and when we get to 7, then we'll start the meeting. So appreciate your patience, and thank you for getting on board.
Hi, Carl.
Hello, how are you?
I'm fine, thanks. We've had a lot of back and forth lately.
Yeah.
Nice to see you in person.
Hello, everybody.
Oh, yeah, that's right. Yeah, everybody just hang tight there. We're getting a lot of people coming in right now, so let's just let everybody get in before we get started with anything. Let's just mute us for a minute. Or not. All right, so we got about 2 more minutes before we get started. And I am personally not a professional sports fan, So it never dawned on me tonight that this game would be going on. I appreciate all of you that are sports fans for taking time away from the game. So thank you for that. And I just saw that the score is now 22 Bills, 21 Chiefs.
Go Bills!
So we'll see what happens here. All right. All right, looks like we got 7 p.m. We have 39 participants at this point. I'm assuming it'll grow a little bit more. First thing I want to do is thank you all for coming out tonight. I appreciate it. I believe that we are all part of the Republican family, and I think we need to treat each other with respect here tonight. I really would appreciate no name calling, finger pointing, whatever we got, but some good, honest discussion about the amendments coming up. That is what's most important at this time. We got a meeting here on the 30th, and I think it's very important that everybody participates in that meeting. So when we start discussing the different amendments, you know, I'm sure there's going to be people that are going to want to comment on certain ones and not others. So we'll do our best to take the calls that we can. I do want to try and limit this to about 8:30 tonight, so that we can all get on with our evenings after that. So just be respectful of each other. That would be my request, as always, as fellow Republicans. Let's do our best to treat each other with respect. I think that's one thing we need to do more of in all our meetings. Looks like we're about 54 now, so very good. You know, and while we're doing this, and while we're fighting this fight and so on, I just want to point out something. Last week, about a week ago, I was on a call with the Wildland Fire Urban Interface Committee. And while we're fighting over little things, and this is little, but it's big in these amendments, but the Democrats are about ready to force some more codes on us on our housing. They're going to raise probably the average price of a single-family home $50,000 to meet these new requirements. We need to be fighting them. And the way I see it, we've got about 6 months to get over our own personal issues here and what's going on in the Republican Party, and then switch gears in a very dramatic way to get people elected in 26. We have a tremendous opportunity to win state-level offices in 26. I think the Democrats have forced enough crap down all of our throats that a lot of people are fed up with them, and we have an opportunity to win. Let's not let this opportunity pass us by, and let's get through all this as adults and then move on to what our real job is as Republican leaders, and that's get Republicans elected. So with that, I think we're at 62 participants, and I'm just going to go right in order with the amendments, and we're going to talk about one a little bit. And I think my personal opinion is that we should not endorse anybody before the primary. That's my personal opinion. Right now, the way we have it, the state's executive board can endorse and has chosen to do so in the past here. I don't agree with it. endorsement of Republicans, the proposed version, I do think does level the playing field a little bit in that sense. It's either all the candidates before the primary of a specific election get endorsed or not. So with that, I'll open this up for some other comments. Anybody like to put their hand up? Does anybody have anything they'd like to say on Amendment 1? Frida, I see you putting your physical hand up. And just know I can't see everybody, and I apologize. We're doing this on a laptop. If it takes a little bit of time, we will do the best we can. Find her. She was down the bottom.
Well,
there you go. Frida?
hear me? I have
Yes, I can.
the same general objection to the notion of endorsing candidates before a primary. That runs counter to, we probably had a neutrality rule for many, many years. I can't even count them. And that got changed at a prior Central Committee meeting. And there was a lot of objection to that. But this provision goes even further. I mean, this provision is designed to not allow, if you will, people to petition on to the ballot. So it's forcing everybody to go through the assembly and convention process. And that's contrary to state law. State law permits either petition or assembly and convention. And it's very disturbing that we're not giving candidates the option to petition onto the ballot. Some of them may be perfectly good. Many of the candidates that we've had in past years, and many of them were very good, who petitioned on. The other thing.
So Frida, I don't believe that's totally true. I believe that you can still petition on. It's just a matter of that the state executive committee can endorse from those that go through assembly, and whether it be one or two, make it that's what that's how that works. You can still, and Mr. Williams, would you correct me if I'm wrong on that?
Right. So the two separate things. If you want to petition onto the ballot, you still can. This only deals with endorsements, and I'll say right now, under the current system, petitioned candidates are not eligible for endorsement anyway. So if you don't pass this bylaw amendment, that doesn't change. Petition candidates will not be eligible for an endorsement from the party. And all this proposal does, is it avoids the Gabe Evans, Janik Joshi situation or the Stephen Varela and Ron Hanks situation, so that any candidate that is designated for the ballot at a particular assembly, if there's multiple, that the endorsement would have to equally apply or there wouldn't be an endorsement at all. And this was based on feedback we had received from the 2024 election. So you don't have to pass it, but if you don't pass it, then the current system will remain in effect, and that discretion will reside with the leadership as opposed to being equally applied if you do pass it.
All right, thank you, Chairman Williams. Frida, does that answer your question or not?
No, it does not.
Then what's your question?
There's another provision in here that says that the state party and others may oppose any candidate who gained access to the primary ballot through petition. So effectively, I've never heard of any situation where we would allow somebody in the party to oppose a candidate who was lawfully put on the ballot by petition. This is just beyond the pale in my view.
Right, but I think what you're asking for us to do is outside the scope of what we can do as far as this bylaw amendment voting this 30th. Okay, so whether you vote yes or no on this, I think we need to address the pre-primary endorsements at a later date if we're going to eliminate this or totally change this. At this point, the amendment is to make it equal, whether it be endorsed two candidates or none after that. So,
well, what I'm saying, Carl, with all due respect, is that this provision, as written, says that the state party leadership can oppose a Republican candidate.
Right, and I don't agree with that either, but at this time, the amendment, we need to address this amendment. And I got Ms. Scholl, Lynette, you got your hand up there? Would you like to comment?
Yes, sir. I know Dave talks about the amendment, and then that would make it equal across whoever was successful in their district. Well, also in the bylaws, it does say that they have to contact that district for their approval to endorse a candidate. So in CD3, we were contacted and we wanted to stick with our decision for CD3 endorsement. So the state went above and beyond. It did not follow the lead of the CD3 district executive committee. So that is a little bit of a concern. I can see the broad, but if they went through the caucus process and that district has voted them in, that's what the constituents wanted. That's what we strive to use as our proprietary. Because when we did it, we went out to each one of our counties, who do you want to vote for? Let's sit down and talk about this. And that's how we did it. That's how we placed our votes. So I just see that might be a little bit of a confrontation to our districts, and maybe other people see it differently, but that's what I'm here for, is to represent our county and our district.
Absolutely, and I appreciate each and every one of you for representing your, either district or county, and expressing your concerns. At this point, do we have anybody else like to weigh in on Amendment 1?
There's a lot of comments, and I'm trying to get to them.
Yeah, we're trying to get into the comment section here, so apologize if we have technical difficulties, but we'll do the best we can. I see, Christy, you have your hand up. Christy?
Yes, sir. Yes, sir. So I just wanted to kind of echo what Lynetta was saying, in the 3rd congressional districts. I'm the vice chair of the 3rd. I know that a letter went out from the chairman on behalf of the district, and so we had tried to address that early on. But at the end of the day, we did contact the 27 counties, and the majority of the counties, based on the language, after communication with the district in question, will be determined to endorse one, multiple, or no candidates. The majority had asked for no endorsement, and it was still, an endorsement was still made. So I don't know if it's just the officers of the state party that make the determination, but that wasn't, I'm just echoing what Lynetta said, that wasn't what we had requested.
Wants to talk about that.
Hope, would you like to respond to that quickly?
Yes, hi, and thank you so much for the meeting tonight. Actually, from my understanding, that the revision or the amendment to the bylaw that we all voted on, the resolution in April, said that we would reach out and collaborate with those districts, and we did. I too made phone calls to those 27 counties, and almost half of them did not get contacted. So when it comes down to collaboration, sure, we're going to take that input, but also based on the current bylaw, it's based on, state party on where they wanted to go with the endorsement. So we did collaborate. We did reach out. I sent out an email. And again, just to reiterate, half of those 27 counties were not contacted, and I contacted all 27 myself.
All right. Appreciate the input there. Marla? Marla? You there?
Yes, hi, Marla Reichert, Pueblo County. I just have a question. Are amendments to the proposed bylaws possible? Because I think this could have potential with a modification that says that we won't actively oppose. Like if the assembly winner were to be endorsed, because that was the will of the body, right? But not opposing in the event that the assembly winner is not successful in the primary, as we saw this last cycle, then we haven't given our oppositions in the Democrat Party ammunition to use against our own people. So is there room to amend these proposed bylaws at all?
Chairman Williams and I discussed that earlier. Chairman, would you like to address that?
Amendments are allowed the day of the meeting, but they need to be germane to the amendment and they need to be within the scope of the amendment, and they can't necessarily expand beyond what was initially adopted or proposed, rather. And just I want to point out one thing real quick, and I'll go ahead and give it back to the chair. The criticism or the concerns that were born out of the CD3 endorsement process between Stephen Varela and Ron Hanks is what's brought about this amendment. So the question isn't whether we should do endorsements or not. We can take that up at a later date. But the question on the 30th is, do you want to keep the discretion with the state leadership, or do you want to make it equally apply to any candidate that gets out of the assembly and is designated to the ballot? So, if you guys want to leave the discretion with us, then vote no on the amendment. If you want to make sure that situations like Ron Hanks and Stephen Varela, they're both going to be endorsed if an endorsement is given, then vote yes. But that's more or less it. And then for opposing petition candidates, that's current policy, and that's not going to be the question that's brought up, whether or not we want to eliminate that. The purpose of the amendment originally, when it was adopted in 2023, was to favor caucus assembly candidates. So, if we want to take that up, in the future, then someone just needs to offer up an amendment. The bylaw committee will provide their recommendation, and we'll have a vote.
So you don't feel like we could strike the opposition language from this particular bylaw?
I don't think it would be germane. I can consult with, if you want to write it up, Marla, and email it to me, I'll consult with Gregory, and then we'll let you know what we think, what the parliamentary interpretation would be.
That's fair.
Yep, I think that's great. I'm going to take one more on this. Michelle? Michelle, can you hear me?
I can.
Okay.
I'm tackling that, which I would like to see that opposition struck because the precedent has been set. Stephen Varela did go through the assembly process. He made top line, and he was actively opposed and slandered by state officers within our party. And so I do have a problem with that language still in the amendment.
So why don't you get together with Marla and write up an amendment to the amendment, however you like to word it. Okay?
Thank you.
All right. Let's move on. We're about 20 minutes into this one, and I want to be able to get through all of it and hopefully keep that 8:30 deadline. And this is Amendment 2, the duties. Would anybody like to start off addressing this issue? Frida, you putting your hand up?
You can tell her to unmute herself.
Unmute yourself, Frida. Huh? There you go.
Yes, my hand was kind of up. And just to describe what my understanding of this amendment would be, is that the state executive committee could hear and determine party controversies with all decisions being immediately enforceable, even if appealed to the courts. I find that very troubling. And the executive committee would also have the power to dismiss quote-unquote frivolous controversies. There's no standard for what constitutes frivolous, but presumably it's within the jurisdiction of the executive committee to make a determination. So I just don't see how this provision permits anybody to make an objection that has anything to do with a party controversy and get anywhere and not have the option of going to the courts before the matter is enforced.
Right. Okay, I hear what you're saying, and I do see there's opportunity here to improve on this and the communication with the state. And I do think tonight's a show of working with each other. The fact that we're on this conversation together and we do have state leadership on it is an opportunity for them to hear us and hear the concerns that we've had over the past year, let's just say. Chairman Williams, you have a comment on this?
Yeah, if there's a specific sentence in the bylaw proposal itself that is bringing up the concern that was mentioned, I'd like to hear it. But as we've put forward these bylaws, I mean, we pretty much put in there that all controversies, all complaints are subject to the State Central Committee's final adjudication. And the frivolous standard, that standard itself is going to be created by the Executive Committee because they are the ones that hear it. But let's say, for instance, they create a standard and someone thinks that they were dismissed unfairly, that their complaint had merit to it. That decision is in and of itself appealable to the State Central Committee. So, the point in bringing this up is admittedly borne out from what occurred over the past 6 months. We have individuals that don't necessarily want to respect the internal controversy process. And when the Executive Committee, which is akin to a trial court, renders a verdict, that verdict needs to be respected until it's overturned by the larger body. And that's all this amendment is trying to reaffirm, which has been the past practice until 2024. So, all I can say is that ultimately the CRC, the State Central Committee, is going to have the final say over these things. But absent this provision, you're going to see more litigation. You're going to see more people drain the party coffers and paralyze the operation of the party itself. So if you want a repeat of what happened over the past 6 months, feel free to vote no.
Well, we want better communication all around. Thank you for that. Lynetta, you had your hand up first.
Yes, I just, in our county, we've gone through exactly the same thing that the state is going through now. So we've had to come up with different ways to handle such a bylaw amendment. So we've come up with an arbitration committee, and that committee handles these and it goes forth. So my concern is that I think the bylaws need a lot of work, and there's a lot of good people here in our committee that we could come up with really exceptional ideas. I think 30 days is not enough time. The state, we need to give more time for communication and to work on these bylaws, because I think an arbitration committee is a great idea for any of these controversies that come up.
I appreciate your input, and I do agree that I do think in the long run, we do all need to really get together on the bylaws and make some meaningful improvements. I'll tell you, here in Teller County, we just went through a 6-month process of revising our bylaws and clarifying some of the procedures for us, because they weren't clear. And our executive committee and our bylaws committee went back and forth for about 6 months before we presented to our central committee and gave them the opportunity to then look at it. And I will say, in second Tuesday of January, we had our vote that night of the 14th, and we had a unanimous vote for our bylaws to be approved. So obviously, the hard work between the executive committee and the bylaws paid off that we had that, and I would encourage that. And I just want to read real quick one of the comments that has come up in the chat from Eagle County. I think it's inappropriate to change any bylaws right before an upcoming Colorado GOP board election. And I don't disagree with that comment. I'm going to go over to Joy. Joy, you had your hand up first. Oh,
She's got to unmute herself.
Joy, you got to unmute yourself. Are you there? I think we lost her.
I'm here.
Oh, there you go.
Can you hear
Yes.
me? Yeah. If you look at the bylaw, it says very clearly that the decisions of the executive committee would be immediately executed. So I'm not sure exactly what room there would be to appeal to the SCC, the larger 400 person body or more than that, from the smaller elite 25 person body. It seems to me very clear that this amendment would shift the responsibility for making these crucial decisions on various problematic controversies that come up, shift that decision-making ability from the 400 SCC to the 25 exec com. It seems very clear. And I would be interested in hearing why that amendment should not be interpreted in that fashion.
Okay, Joy, 1 second. Dave, I'll get to you in a minute. CJ, you had your hand up. Do you have something different to add or no?
I'm in the same vein. The idea that the executive committee can enforce, the bylaw does not provide that the central committee can enforce. And so I wonder what enforcement means. What sorts of actions are contemplated by the proposers?
All right, thank you, CJ. Chairman Williams, do you have an answer for that?
Sure. Well, first off, 2024 was sort of an experiment, if you will, by those who wanted to challenge the norm of what's been done in the past. It's always been understood that the executive committee's decisions would be executed immediately unless overturned by the central committee. We wanted to put that in there so that there would be no doubt or an attempt by others to try and push the boundaries or even cross the line on that. And the reason we did that is because, as was well documented, when there was a request for a special meeting for the removal of the officers, that was challenged through the controversy process. And when that was found to have been overturned, or rather the petition process was found to be invalid and everything else associated with that by the executive committee, those who wanted to press forward with that meeting, special meeting, decided to go do their own meeting, and then the rest was history. So, the point in making sure that these decisions are executable is not that dissimilar from what you would see in a trial court. When a trial court issues a verdict, whoever is on the losing side is always able to appeal, but that doesn't necessarily mean that the decision that was rendered is somehow unenforceable or stayed at the moment. And that's really what we're trying to get at, is that once a decision is made, that's policy until it's overturned. And then once the Central Committee renders its final verdict, that's the policy that will be then executed, until the Central Committee decides otherwise. So that's the purpose of it. The Central Committee always has the final say, and it's important to know that every single executive committee decision that's been decided during this administration has been upheld and reaffirmed by the majority of the Central Committee itself. And then the executive committee, I don't know what to tell you guys, the vast majority of the executive committee is elected by you guys. I get like 4 appointments at most. All the guys are elected by you, so if you don't trust them, I don't know what to tell you. You chose them.
So Dave, then how exactly do we appeal to the Central Committee? What's the exact process, and how will that be honored by the Executive Committee?
Well, the appeal process is fairly simple. After a verdict has been rendered by the Executive Committee, you have 12 days to appeal. And that's what happened with Nancy Pelosi and Todd Watkins when they had an adverse ruling concerning their special meeting. They sent an email to me, and I believe they copied others as well. Once we got that, we noted it, and we went ahead and scheduled it for the CRC's consideration. And it's as simple as that, and that's outlined. I don't remember the page, but I think it's like page 20. There's a process for just simply, you can appeal, and you just got to notify the leadership that you want to.
All right, thank you. Joy, you had your hand up first?
Yeah, I just need to say that I just find this all just very specious. Dave Williams knows that the first person to sue, the first entity to sue, was Dave Williams, to sue the Todd and Nancy rebel, what I call the rebel force, and he did that to stop the meeting. And the judge first put a temporary restraining order on that special meeting, and then he removed it, which means that he found, and he said this in his decision, that it was basically perfectly legal. And that's why the meeting took place. It was perfectly legal. What happened, and so what happens is now we have a 25-person elite group that's going to decide whether or not controversies go anywhere. And I find that to be very repressive of the freedom of speech and freedom of assembly, and that's what it is. I think it's a wrong way to go for a party that prides itself on believing in American foundational values like freedom of speech. It's repression, and it's not allowing the rebels or the dissenters, i.e. the founding fathers, would be shut down by this party because of rules like this. It's ridiculous, and it's really, really alarming.
Thank you, Joy, for your comments. Todd, you were next up online. Do you have a comment here?
Yeah, Joy kind of covered it. I was, very grateful that the idea of a trial court was brought up, because a trial court did actually find in our favor and allow the meeting to go forward. And if, the state party thinks the executive committee has that level of authority, why did he take us to court? And essentially the trial court overturned that ruling, and we proceeded with the meeting.
Okay, thank you, Todd. CJ?
I think the analogy that the executive committee would be acting like a trial court and the central committee is an appeals court is false. What we really have is a situation where the executive committee is more like a magistrate or a mediator that can hear the dispute and
Executive committee makes.
Hold on, Larry.
Okay.
Let CJ speak.
But the judicial authority of the party rests with the central committee, and that should not be delegated to the executive committee.
Okay, thank you for your comment. Lynette, I believe you were next up that I saw. Did you have a comment or no?
Well, I did put my hand down, but if I know there's a lot of comment about the money and the suing and stuff, but if we would have followed the bylaws, had a budget by June 15th that the State Central Committee approved with a line item of legal expenses, then that would eliminate that so-called 100,000 or extraordinary expenses, because it would had to have come back if our line item was 20,000 and we went over to 100,000. It would have had to come back to the State Central Committee for a vote.
Okay, thank you. I just want to reiterate to everybody that we're doing a good job so far of having a respectful dialogue here and conversation about real concerns that people have. Let's keep it that way, please. Chairman Williams?
Thanks, Carl. I appreciate the opportunity to at least get the facts on the table. First off, the Arapahoe Court did not rule in favor of the legality of the suit that we brought forward. He actually ruled on the jurisdictional aspects of it, which paved the way for them to proceed, which we have appealed to the appellate court, and that is ongoing. So that's number one. Number two, the reason we filed the litigation was to enforce the executive committee's decision, because Watkins and Palazzi and everyone else involved in that did not want to respect it. It's important to note that they appealed the decision, the adverse decision that the executive committee had made after we had filed suit. And I think we filed suit maybe 10 days later after understanding that they wouldn't necessarily adhere to the internal process and the system in place.
All right.
So it's important to know. And again, the executive committee is elected by all of you guys. So if you're upset and you don't trust the executive committee, I don't know what to tell you, because I didn't appoint them. You all elected them.
All right. Thank you. Daryl Felon?
Yeah.
Can you hear me?
I got it. Yeah, I got you. I got an overall comment. I'll probably come in at the end. This is just on this discussion here. I'd like to know what the conflict of interest policy is for the organization, because you really had a group of people that initiated a process against a set of officers, and those same officers then were involved in the process, where in any other normal company, if, say, the CEO of Microsoft was accused of something, he can't be in the arbitration decisions of whether or not that meeting's going to happen to remove him or not. And so if the action was there has to be a process. I would assume that the Republican Party been around more than the last 23 months, that if there's a conflict of interest, how do those officers, get out of the side? And somewhere, if the SEC was in the compromise was with the SEC, then the SCC should have been brought in the entirety. Now, the requirement was the 25%. My understanding that the 25% was met. It was the officers that were involved under the question that the 25% were asking for the meeting, making the decision. And I'm not even going to go into all the other calls, whether calls were legal or not legal, or the meeting under the bridge, or the other annex that
let's stop there. Let's stop there.
Yeah.
And let's stick to this amendment. I'm only going to allow for 2 more minutes of conversation on this amendment anyway. And we all understand that the dissatisfaction with how everything worked last year.
If we argue just everyone their little piece and not the comprehension of it, we'll sit here and stroke that chicken wire canoe.
And that's why we're not. Yep. All right, so Amendment 2, and I do believe, if somebody wants to write an amendment to the amendment that would maybe define that frivolous and how the procedure goes on beyond that, then we'd welcome that, and you need to get that to Chairman Williams. All right. I just want to, so we did have another comment, and it's about the process, that they feel this process seems to be incredibly rushed, and that's part of the reason for so much pushback. These might be good ideas, but without having appropriate time process, those prior violations is problematic. And there is also the issue of making these decisions right before new leadership vote, also feeling rushed. And I think I've already expressed that. And I hope that the executive team is hearing the frustration in that, and it's not just from one or two people. So with that, I'm going to move on from Amendment 2, and we're going to move to Amendment 3. And this is the nomination method, selection, meeting. Does anybody have any off-the-line comments on this or questions about this amendment? CJ?
Yeah, I just had trouble understanding exactly what the amendment does. It's fooling around with dates. I don't know the CRS well enough to understand what difference this amendment will make and then why it's a good idea.
Chairman Williams?
Yeah, thank you. The amendment, for the most part, is a technical language cleanup. Functionally speaking, there's not much that's going to change. The one change that would come about is the time frame itself. Under the current proposal, a meeting has to be held between August and the end of September to have the vote. And with this change in language, it would allow for a greater period of time and more flexibility for the next administration to schedule this vote. So there's really, there is no functional change other than it's better grammar, and it allows for a longer window to consider the vote.
CJ, does that answer your question?
Yeah. So now it's got to be by October 1st, and what is it today?
It's October 1st.
And just what is the change in terms of the time frame? Is what I'm trying to get my head around.
Instead of the meeting having to be held between August and that October 1st deadline, it can be held any point in the off year before October 1st. That's all.
Thank you. I understand.
Okay. Anybody else have any questions or comments on Amendment 3? Frida?
I'm not sure I fully understood Amendment number 3 because it seems to go to the same issue that we voted on repeatedly, which it has to do with whether we want to opt out of the primary election. And because if unaffiliated voters are permitted to participate in our primary election, there was and I see that 75% of the membership of the Central Committee has to vote to opt out as long as unaffiliated voters are participating. And the requirement to opt out was 75%. I see that's of the membership voting affirmatively to opt out. I see that that's crossed out. And in past elections or voting on this, that 75% threshold was never met. And so I wonder whether that's the real purpose of this change.
Dave, do you have an answer for that?
The bylaw still references the state law, which is the controlling policy that still has the 75% threshold requirement. So nothing changes because the law is still referenced, and that's still the law that we have to adhere to. This really only changes the grammar and extends the window by which the next administration can schedule a meeting. Typically, the meetings in the past have always been in September, and sometimes they've been at the end of September, sometimes they've been in the beginning or towards the middle. Never in August, at least that I don't recall. Again, this is more of a technical language cleanup bill that doesn't change the requirements because state law is state law.
All right, thank you. All right, any other questions on this? On
3.
Okay, on 3. Then let's move on to 4. And I'd like to just say, let's if you're going to speak about situations and stuff like that, let's not address the individuals, but the situation. If you wish to address me directly by name, that's fine. But let's just be respectful of each other and the situations where we find ourselves in here. Amendment 4 is removal. Any elected officer of the RNC National Committee Man, Committee Woman of the CRC may be removed from office at any time for whatever cause the CRC may deem sufficient by a vote of 2/3 of the entire voting membership of the CRC. Do we have anybody who wants to comment on this?
Yeah, Carl, I'll speak to it. This is Christy, the National Committee Woman.
Thank you.
Yes, sir. So I was going to speak on it, but I actually would like to defer to the state party and ask them what the motivating factor was on this amendment. I think I know, but I'd like for them to speak to it first, and then I'll come back with comments on that, I think.
Chairman Williams?
Thanks, Carl. We initially looked at the removal vote because of, or the bylaw, because of what happened in the Eli Bremer, Watkins, Palazzi lawsuit.
Let's not address the names, please. Address the situation.
Okay. The litigants in the El Paso County lawsuit, the ruling that was rendered clearly outlined that it took a 2/3, or in this case, a 3/5 vote of the entire Central Committee, and so we wanted to correct that. As we were drafting it up, what we noticed is that there appears to be no removal procedure written out as it pertains to the National Committee Man and to the National Committee Woman. In the past, it has been considered, it has been interpreted that the National Committee Man and Woman are also officers, and then that this provision would apply to them anyway. But given the events of the past 6 months, we wanted to clearly spell that out and raise the threshold from 3/5 to 2/3, because that is more or less in alignment with what the other counties have, and admittedly, it would make it harder to remove any of those elected leaders, and that's kind of how it should be. I think what you witnessed over the past year was a minority faction trying to remove duly elected leadership, and that was over policy disagreements, and that's not something that we should be engaging in as an organization. In other words, if you're going to remove officers or the RNC committee man and woman, then you should really have a darn good reason that could get to 2/3. So it was a comprehensive sort of redraft of the removal bylaw born out from the ruling that happened in October.
Thank you. Christy, did you want to address that? And then Marla, I'll get to you.
So I know that this specific meeting was referenced, and so I'll just say that when I was elected on a platform where I said that I would listen to the people's voice. And so my involvement or my attendance in certain meetings was due to a request for me to be there and hear from the people that put me into my position. And so I've taken a lot of arrows lately from a lot of different places, and I'll be respectful and I won't name names per your request, Carl, but this seems to me like this is a very specific thing based on that, based on some assumptions or based on certain actions that were taken that I was present for. And regardless of what my personal feelings are on that, what seems to be avoided here is representative government. We seem to be avoiding the fact that we were all elected to our positions to represent the voice of the people that we were voted in by. And I think that we would go a long way by remembering that before we start trying to make changes and start to attack each other. Now, I'm curious, Dave, can you just clarify that what members put these amendments together, all 6 of these amendments? Was it just the 3 members that were elected to the state party, or was there a committee that was part of that? Was the bylaw committee involved in that, John Fielding?
The final language that you see is a collaboration of the leadership team and the bylaws committee.
All right, thank you for that. Marla, did you have a comment on this?
My concern on this one is that the committee man and committee woman are elected by a different body, a substantially larger body of, 3,500 to 4,000 people generally. And the state party officers are elected by a much smaller body, being the state central committee. So I feel like it's a really bad look to tell the 4,000 people that voted at the larger body that, we're just going to throw out how you feel. I just feel like to whoever made the point about, listening to the people who were voting, it seems heavy-handed to me. That's my concern with this one.
Thank you. Lynette? Lynetta?
Actually, thank you, Marla. I didn't realize they were voted. I had forgotten they were voted at our assembly, so that does make it a larger voting population there. So my comment is mute.
Thank you. Chairman Williams?
Thank you, Carl. I just want to point out a couple of things. The assembly itself is statutorily required to meet within a 1-month time frame every 2 years. And that's why in our bylaws, in which this was reported in the committee report, is that we actually, as a body, as a central committee, select into those positions if there's a vacancy. And the reason for that is because of that 1-month time frame out of 2 years. And so if a national committee man or national committee woman were to ever do something that was terribly egregious, and I don't know what that is, effectively, by voting no, you're saying that there's no recourse, there's no removal process. And every elected position, every elected official in public office and in any other major party office, there is a removal provision for them, and rightfully so. But you'll note that we had an increase from the 3/5 to the 2/3, and so if there's an implication that somehow this is heavy-handed or in response to the actions of any of the current membership of those 2 positions, I'd have to say that that's non-existent and that's not correct. It's very hard to get 2/3 of an entire body of anything. So again, there's a gap in our bylaws. If you vote no on this, then a committee man and committee woman can pretty much do whatever they want without any sort of accountability, because that assembly, that state assembly, can only meet once every 2 years. And there currently isn't a process in place for them to actually remove anything. And that would that would inevitably, without this, it would come up, it would just be at the discretion of the chair, whoever that may be, of the state assembly and the state, of the state assembly and convention. If you're all comfortable with leaving a gap in place to where someone can't be removed when every other elected position that you can think of has a recall or a removal process, then vote no.
All right, Christy, did you have anything to add? Because it's your position.
No, sir, I appreciate it. For the sake of time, I'm good. Thank you.
All right, thank you very much. I'm going to read a comment here,
Which one?
and I'm just going to paraphrase it a little bit
Which one?
about the coup.
Oh,
Anyway, somebody put a comment in here about the continued coup, and I'm going to tell you, there's nothing more frustrated about. It's about righting wrong brought about the actions of this continuous coup. You know what? I'm sorry, but there are people that have different opinions, different agreements. And if we don't have the opportunity to speak about those freely without being called names, well, then we're not the Republican Party anymore. And that's what I'm going to say on that. I'm going to move on. Michelle, did you have a comment on Amendment 4?
Yeah, I just wanted to reiterate again, if there is a removal process, it can't be done by a separate body. They were, and it's illogical too. I mean, one of the things that Chairman Williams says is that we got that Proposition 10 and the opt-out because of the convention that was held in Pueblo, and we cannot revisit it for 2 years. Yet, it seems to me illogical that we can remove committee men or committee women not using the same process. It just, I just scratch my head. This is totally against Republicanism as I know it.
Then vote no.
this is a good question.
So a question came up here in the chat. Does the national GOP have the authority to remove a national committee man or woman if there is a problem? I cannot believe there is no process. Does anybody have an answer to that? Chairman Williams?
There is nothing in the Republican National Committee's rules that allow for the removal of an RNC committee man or woman. They leave that up to the states. And I would further reiterate that the bylaws currently allow us to select, in the event of a vacancy, to fill a national committee man and committee woman. Now, if there's an amendment that wants to be brought forward, probably in the future, because I don't know if it would be beyond the scope or not, but if there's an amendment to say declaratively that the state convention assembly within a 1 month period can remove a rogue RNC committee man or woman, then bring it forward. But guys, the reason we're bringing this forward is because doing it one time or having the opportunity to do it one time every 2 years seems pretty limiting when every other officer can be removed, and when you compare it to elected officials when they can themselves be recalled at any time should there be sufficient support. So vote no if you really think that this isn't if you think it's a good idea to allow no accountability on the RNC committee man and woman. Vote no.
Yep. Thank you. Last question on this or comment, Lynette.
Yeah, and I understand what you're saying, Chairman Williams. It's just that the vacancy is a little bit of a different process, because if we have a vacancy, say, as a county commissioner that has died, we have already formed that vacancy committee through our reorganizational meeting. So it's not the same purpose, and to recall a county commissioner is based on the voting numbers of Republicans that voted during that election, and we have to have that many signatures. So it is a little different than just replacing a Republican National Committee person because they can no longer fulfill their duties or anything like that. That's why we have a vacancy committee.
Thank you. All right. Let's get into Amendment 5 at this point. Suspension. Would anybody like to address this first?
Todd was going to talk.
All right, Todd, would you like to address this?
Well, some comments have come up about retribution, and I'd like to point out that this is 100% retribution. Also, somebody had asked earlier, I think it was the National Committee woman, about who penned these, who's the author of these 6 amendments, and the chairman did say that the final version that we have right now, I presume he means what was sent out in the email with the additional changes and redactions, was the product of the 3 officers and the bylaw committee. It was already stated to the meeting on the 14th that the 3 officers were in fact the sole authors of these bylaw amendments, and there was no consultation with the bylaw committee to present them. So it's hard to say with any sort of credibility that this was not born out of a sense of retribution for what has transpired over the last so many months. So, in fact, the original version of this had a specific case identified in it, which was targeted exactly at Nancy and me to make us suffer for challenging the state party, the efficacy of the chair and the other officers. So, I'll begin here by saying that the gnashing of teeth and beating of breasts that has happened with the expenditure of funds, that was all the purview of the chair and the other officers who sought to sue Nancy and me. We did not.
Todd, I'm going to ask you to only address yourself by name and nobody else. I ask that of everybody.
I understand, but this amendment is so specifically targeted at me and the chairwoman of the Jefferson County that it is very difficult to not mention how it came to be and the persons involved. This is a very, very personal amendment. I think that is patently obvious. But the only case, the original case that spawned this was brought by the state party against 2 party members. That case was lost, and it is being appealed. So to the second part of this amendment, which talks about a failed litigation, one would wonder exactly what qualifies as failed litigation, because the only litigation that failed was that which the state party brought. That's why it is in appeal right now. This section shall not apply to individuals who enter into a settlement. The El Paso case, the one that was first specifically named, that was settled. That was not failed litigation. It was not lost. The only thing that was lost was a vote. We dropped that case, and there were agreements to walk away. There were release of claims signed by all parties of this litigation.
Okay, thank you for giving your opinion on that and this amendment. Chairman Williams, would you like to clarify this amendment?
Sure. Well, first off, I want to correct some factual errors. This idea actually was not brought forward by any of the officers. It was actually brought forward by someone else. I won't name their names. I think they're on here, so they can raise their hand if they want. And it was actually brought forward well in advance of its release. The problem we ran into, and this is what our chairman of the Bylaws Committee told everyone on the 14th, was that he had some health issues. In fact, he has ongoing health issues to date, which sort of got in the way of the drafting making process. But nonetheless, we were able to put something together, and the Bylaws Committee was able to take in the feedback from the 14th and provide amendments that not only struck out the specific reference to the El Paso case, but also made very clear that the final decision makers on what's failed litigation or who that would apply to is the Central Committee. all of these amendments do harken back to the Central Committee itself. And in this particular instance, this is a necessary bylaw in order to prevent offensive litigation against the party. And make no mistake, there was failed litigation in El Paso. A judge dismissed the crux of the case and made a very declarative statement that there was no removal of the current officers. That's failed litigation. And the settlement also does not apply in whatever settlement agreements may have been had between the litigants in the El Paso case. You'll hopefully understand that the ruling that the court made, it deliberately carved out the state party. In other words, the state party was not involved in any sort of settlement agreements of any kind. And so that's important to know, I suppose, in the backdrop of all this. But the reason to pass this, and I admitted it on the 14th, was this needs to be a deterrence. And taking away the El Paso case or the Arapahoe case, the party has been sued 3 times, spanning 3 chairmen. The first involved a dispute with then Chairman Ken Buck, and then there was a litigation against Christy Burton Brown involving El Paso, and then of course there was the litigation this go around. Collectively, that cost the party about $200,000 in donor resources. The point of this amendment is not punitive, especially since there's a provision in it for those people to get back into good standing once they've paid restitution to cover the cost of the party's defense. So that's why it's not vindictive in any way. It allows a way for those people to come back together and restore whatever relationship there was prior. Absent passing this amendment, you're going to see minority factions, like we saw the past 6 months. You're going to see minority factions sue the party and paralyze it and drain it of its resources. And so what I would suggest is that let's just pretend for a moment I'm not going to be chairman in this upcoming term. There's going to be a new one, and perhaps the people here think of the very candidate that you want actually wins. I guarantee you that you're going to want them to be in a position where they're not having to be running a paralyzed organization that's draining money. I certainly did not appreciate what happened, but let's just say, for example, that one of the litigants that were in opposition to myself and the officers, let's say they were chairman of the state party. I would not have wished this upon them, and I think it's appropriate that we have a deterrence in place so that the internal process is respected, that whatever we decide as a body collectively in the Central Committee, that's what we're going to do, and we're not going to go to an outside court if we can help it.
I think this is, I appreciate the dialogue we're having here and the honesty about the difficulty of the situations we've all faced this last year. And I do hope that in the future, regardless of who sits on the executive committee or the Central Committee, that we can have better conversations and resolve our differences in the privacy of our family, the Republican family, and get it done and come up with reasonable solutions that help the party grow and help candidates get elected. So once again, I appreciate everybody. I appreciate your time tonight and how we're having these honest conversations, because it's the only way we're going to get past them and move forward with winning in 26. So I don't know. I don't know if we have any other comments on Amendment 5. You all, you have the right to vote against it or vote for it. And is there any further comments before I move on? I'd just like to say one more thing, and I meant, over the over the past 10 years approximately of being heavily involved up here in Teller County with the Republican Party, it's been an amusing ride in a lot of ways. I've been called everything from a grassroots activist, a local activist, to a rhino, sometimes in the same meeting. And I find that interesting. And I wish that we could all just be Republicans and work together to get people elected. You know, and it's funny, I feel, particularly the last couple of years, I have probably pulled more Republican knives out of my own back than Democrat. We need to change that philosophy of our party and how we work together. And I wish that this be the start of having those difficult conversations, that in the end, we end up being a stronger state Republican Party and we get Republicans elected to state office once again. If there's no further comments on Amendment 5, excuse me, Amendment 6, now there's a little bit of confusion on this. Chairman Williams and I talked about this earlier today, and I believe this amendment is still on the table, but it's in review. Chairman Williams, would you like to address that, please?
Sure. Depending upon how quickly we can finalize the legal review on this one, we may have to lay this over for consideration to a later date. And the reason that we want to do that is we want to make sure that the committee, the Central Committee, has plenty of time to digest the Bylaws Committee's recommendation in light of the legal review that was requested with it. A part of the reason we're having a bit of a delay on this one is we did offer an amendment that somewhat changed the flavor of Amendment 6. It increased the number of voting members per category, but it also provided additional membership to all the counties. We did that. We wanted to do that because right now under the current system, especially with the elected officials, there is a disproportionate amount of voting power with red counties that have a large number of elected officials. And so when you compare El Paso County, for example, to Jefferson County, by virtue of those elected officials being there, they're going to, El Paso by default is going to have a stronger voting push. So we felt that we could give every county an additional voting voice to the State Central Committee to make up for that disadvantage and level the playing field. And the beauty of that is that the bonus member thing stays intact, so the counties that perform better through an election, they get a proportional increase based on that election. And then by giving each county one additional member at large, that also gives a floor or a baseline for each county to have some more equal voting representation to the State Central Committee. But the question for number 6 generally is, is this legal and what's the purpose of it? And the first question is, we believe it's legal, but we are going to wait for the legal analysis to be completed so that we can present that to all of you. And the reason we do think it's legal, though, is because the law in question talks about membership, not what type of membership that would look like. So right now in your current bylaws, what you'll notice is that there are voting members and there are non-voting members. And we've had that for decades going on right now. But one of the most objectionable things that we saw in this law, which is probably unconstitutional on its face, is that the General Assembly, the members who passed this law, forced membership into this political party. And if you were to take that to the extreme, we'd hope that intellectually you would agree with us that in no way, shape, or form should an elected official use the force of government to confer membership rights in a nonprofit organization. So if the General Assembly, the legislature in this case, if they voted for a law to say, hey, we want to be members of the United Way or the Boys and Girls Club or the Salvation Army or the NRA or whatever organization, I'm sure most of you would disagree. The question is, why is it appropriate for a bunch of politicians to get together and confer upon themselves with the force of government membership rights into our organization? And what we looked at are other states and the Republican National Committee for a little bit of guidance on this. I don't know if it would surprise everyone to know this, but the President of the United States, Donald Trump himself, does not have a voting right on the Republican National Committee. He is not a member of the Republican National Committee. Neither are their congressmen or Republican senators. They don't get a vote. They can exercise their influence, and they'll have great influence and say over the direction of the party, but they are not granted a vote. So the question we wrestled with is, well, why are the other elected officials here in Colorado, why are they more special than the President of the United States? And the answer is they're not. And so I think ultimately what we came to was that if you want to be a part of the party, then you need to earn the membership like everyone else here. All of you ran to be county officers or bonus members, and you won support in order to represent the Republicans in your area to the state central committee. It should be no different. So we think that elected officials should not be just given something on a silver platter, that they should actually run for it and earn it like everyone else. And we do take offense to the First Amendment freedom of association violation that the legislature has admittedly and provably done. They passed a law that gave themselves voting rights, or rather, not voting rights, but membership rights into our organization. And for those reasons, and I think one of the most important reasons, which is damning, is that 88% of the elected officials over the past 2 meetings have not actually exercised their membership rights. They actually do not show up and do not participate.
All right, Dave, thank you. We only have a few minutes left before I want to try and cut this off, and I got a couple more hands up on this issue. Christy, what do you have?
Yeah, so that actually changes my question a little bit. I'm just curious, has the NRCC or the RNC weighed in on any of these amendment changes?
Who is that a question for?
Probably Jay would probably be the best one to answer that.
Did you hear that question?
Yeah, no, they have not weighed in on this stuff, and they don't, as a policy, don't typically weigh in on any bylaw changes in any states.
All right, thank you. CJ?
Tell them to unmute.
CJ, unmute yourself.
Okay, can you hear me now?
Yes, sir.
The idea that the President of the United States can't be on the Republican National Committee may be persuasive if we didn't want the governor of Colorado to be on our state committee. But I think we really want elected officials to be on the committee because that's where we exist. Those are Republicans who run for and know how to win office, and we need their wisdom and guidance in the Central Committee.
Thank you for your opinion.
I've had my hand up quite a while.
Larry, I haven't seen your hand up, but go ahead.
Not in this one, but in the past ones I haven't been able to speak. Government in this country is bottom up. People are the authority, not elected representatives, but normal, everyday, grassroots people. That's the way republic works. And for the state government to mandate their own membership in a party is not Republican by any stretch of the imagination. If we don't want to be Republican, let's just not call ourselves Republican. If we want to remain under government control, then let's just give it up. Because that's what this is government control telling us who we can have as members, how we can get our members, who we have to allow to vote for our nominees. It's totally defeating of republicanism.
I appreciate your point of view, Larry. That's a good point. Thank you. Does anybody else have a comment on this amendment? Chairman Williams?
Yeah, I just want to clarify that all the elected officials would still remain as non-voting members. They would have every other right afforded to them, so they could come to a meeting, they could be recognized, they could even make motions. So they would still have the ability to exercise influence within the party, because right now, even though we feel the law itself is unconstitutional, it's still the law, but that doesn't mean we have to necessarily allow them to have voting rights, especially given the fact that President Trump and many others don't have that same ability, and all of you had to run to be a voting member of our committee. I don't see why.
Right. Thank you. Yep, thank you. Michelle?
Yeah, this just reminded me of the last meeting that we had, and I'm back to Amendment 4 or 5, Amendment 5, and Chairman Williams, maybe you can clarify, didn't you state in the last meeting that anybody who participated in a difference of opinion or the coup or whatever you want to call it, that they could be elected as a bonus member, chair, whatever, to their party, but they would not be a voting member at the State Central Committee?
I'm not sure. Is there a clear question there, Michelle?
Yeah, well, I think the clear question is, and so we're saying that in Amendment 6, our elected officials will have every right except the right to vote. Is that the same as what's in Amendment 5 for current committee or current county officers that the party has deemed, just under Amendment 5?
So Amendment 6 is written in such a way because the state law mandates membership generally.
Okay.
With respect to 5, anyone who the Central Committee deems to put suspended membership rights on, that would only apply to the State Central Committee. But if they were elected as a county officer or a county Bowman's member within their own counties, we wouldn't be affecting that. That would be up to their own counties what they want to do. So theoretically, those membership rights at the county level would remain the same or be subject to whatever the county wants. Number 5 just applies to membership at the state level.
Thank you. Now I have Representative Carlos Barron. You have your hand up?
Yes, sir. Thank you very much. Good evening, everybody. I'm Representative Carlos Barron for House District 48. Recently elected this November. For the first time, I was a council member here in Fort Lupton for a while beforehand, and I'm glad to be here. Just want to say on Amendment 6, I disagree and respectfully, Chairman Williams. We also ran a campaign to be elected, so we are an elected in an elected position by the people. I didn't really get very much communication from the state party during my election, during my campaign. I got a lot of help here from the Weld GOP, which they were great. They helped out a lot of the candidates up here north. And I believe that we should have a voice in this state party as well. Respectfully, we did run a campaign and we did get elected as well. So the people did speak in our district to represent them. And that includes not only in the state, but also in the state party as a Republican. I really do enjoy being here and listening to all this. And I really want to put my word in here and be very respectful. And I appreciate your time.
All right. Thank you very much for expressing your opinion on Amendment 6. So, Mr. Watkins had his hand up next, and then Kristen, I'll get to you.
Okay, with regard to all of these amendments, whether 6 gets pulled back or not, it's important to understand how these amendments, as they were originally intended, and I believe as they are still presented right now, this represents it's a consolidation of power and giving more authority, near plenary authority, to the chair, the officers, and the executive committee. It is designed to reduce the voting body, the number of votes that the Central Committee has. I think if you look back historically, you will find that, with particular regard to the elected representatives like Mr. Barron, that bloc has typically voted against the initiatives of the current administration. They've not gone with the what the current administration has tried to achieve. With particular regard to the opt-out, it is also important to understand that one of the primary objectives of this administration and these bylaws to drive that to that end is to facilitate an opt-out by some way, shape, or form, by hook or by crook. They want to opt out of the primary election, and the reason for that is to remove the ability for Republican candidates to petition onto the ballot, thus making the only path to the general election is the assembly. And I'll let your imagination go where it wants with who that benefits. But this is all about consolidating power, about reducing the number of votes that could possibly oppose the current administration, and to intimidate and frighten any members from voicing any sort of dissent or using an avenue in the bylaw to address grievances when the chair is deaf to them.
Thank you for your weigh in on that, Kristen.
Thank you, Carl. I just have kind of a technical question or point regarding Amendment 6. I apologize, I was not able to attend the meeting on the 14th, so I don't know if corrections had been made. But I believe there's actually an error in Amendment 6, which I believe means there's also an error in the current bylaws. So there is a reference in Section A to the Colorado Revised Statutes, Section 1-4-702, and that actually doesn't have anything to do with party membership. I don't know if anybody had caught that. It seems to me that that needs to be corrected to 1-3-103 and probably 2A, so that it's a proper reference to Colorado Revised Statutes. So whether we address this now or in the future, I think we need to look at getting that corrected. Thank you.
Chair, do you have an answer for that? Did you realize, recognize that error?
It's number 6, and I tried to email John Fielding, and the email bounced. So anyway, it's Amendment 6 where it talks about who the voting members are. It's under membership defined.
Okay, and I see the reference here.
I'm pulling it up right now. Why don't you go to the next comment as I pull it up, Carl?
Okay. Ms. Scheppelman?
Yes, thank you so much. So I do want to address one, I guess, question / comment. I actually am in support of Amendment 6. And the reason being is because we do have a representative here in our district that did not uphold their counties and districts' wishes for a vote at these state central committee meeting. That individual ended up having a personal conversation with me, and basically they voted the opposite way of their district because they were running for re-election. And to me,
I can never pay for that one.
And to me, that states, we are all representatives of our counties, our districts, And we should be voting based on what our PCPs, our county executive committees, or our state executive committee wants. And so when I look at Amendment 6, it's about holding people accountable for their districts and their counties as well. That's how I'm looking at it as well.
Okay, I appreciate that. And I just want to say that I don't agree with governing to the lowest common denominator all the time. It puts it restricts the people trying to do right, and it's shameful that whoever that was in your district that went outside the box there, and you have the recourse of voting that person out at some point. Mm-hmm. So I think that's always reacting and creating laws, bylaws, whatever it is, to the lowest common denominator, I don't think benefits the mass of any organization or group of people. That's just my comment on that. Chairman Williams?
And I believe it was Kristen that brought up the reference. I have
Yes.
the bylaw proposal up right now, and it referenced 1-4-702. That's the opt-out provision, and the reason it references that is because it talks about total membership relating to voting members and non-voting members. So that's a correct reference, unless there's another reference that I'm not seeing. There's no drafting error.
So in Amendment 6?
In Amendment 6, where it
Yes.
says
Okay.
1-4-702, that's a correct reference.
When it's talking about defining total membership.
Yes, for purposes of the opt-out, because there's two categories of membership.
Okay.
Voting.
So perhaps part of the problem is it just wasn't clear based on what was sent where that was coming from. Thank you.
Okay.
All right. With that, we have reached our 8:30 mark, and I'd just like to thank you all for participating. It looks like we had about 75 people at the highest 80. 80.
I know Lee wanted to talk.
Anyway, really appreciate everybody's taking the opportunity to be on here tonight and having the opportunity to air a little bit of difference in what's going on. And I don't think 70 or 75 or 80 people is enough for the 30th. Everybody needs to get on that call. Everybody needs to vote. And I do want to just clarify for everybody on this call how that how that vote's going to take place. And Chairman Williams and I talked about this afternoon. And so everybody will have on their computer, you'll vote electronically, but that electronic signature will be directly to your name and recorded how you voted. And that will not be seen to the general public there. And I believe there will be a process if somebody does want to get the vote list, that they'll be able to see how the votes went, who voted for what. Is that correct, Hope or Dave?
We don't plan to publish the voting results, but if any member wants to see how anyone specifically voted, we will make it available.
Okay. So that will be the transparency factor in this electronic vote.
There's another.
So I just want to read one more comment, and it's been an ongoing theme. I think these bylaw changes need to be shelved until after the Colorado GOP board election. So there is a feeling of that rushness here that's been echoed throughout the evening. I believe I had one more hand up. Darrell, did you have something? Larry?
Yeah.
Larry, did you have a comment?
Just a second. Yes. Just in reference to what Hope said about representation on the Amendment 6, I think it was, removal, 5 maybe. And those representatives are to represent their constituency, but they also take an oath to uphold the Constitution. and the Constitution the same way that it overrules oppressive government, it overrules wrong majority rule. It's constitutional government by representation. Just to clarify. Thank you.
All right, thank you for your comment. Mr. Fillen, did you have a comment? All right, not hearing any. All right, thank you very much, and I appreciate you are all leaders from around our state representing the Republicans of our state. And I think it's so important that we have this opportunity and that we had this opportunity to air our grievances or feelings about these amendments. And I would encourage each and every one of you to reach out to your voting members in the Central Committee to be involved on the 30th so that we can have a representation of the whole Central Committee and not a small group of us. And with that, I'd just like to say thank you to you all. Appreciate you. Let's have a happy new year. Let's get Republicans elected in 26. Let's make the best of this opportunity that President Trump has really given us. We have so much to be thankful for in this country, having President Trump as our 47th president. Let's make the best of it, and God bless you all. Thank you all for this evening.